Gold.
Thank you, Your Honor. We're here in the state of Ohio versus Robert Jefferson, case number 25CR1421. The defendant is present with counsel Michael Goldberg. We were last here on December 23rd, 2025, where the defendant pled guilty to count 3 of the indictment, illegal use of a minor in nudity-oriented material or performance, a felony of the 2nd degree with a forfeiture specification, as well as counts 4 and 5, voyeurism, felonies of the 5th degree. And we are here today for sentencing.
Thank you. Before we proceed to the sentencing hearing, I'm going to address the defendant and explain to him what his responsibilities will be to register. We'll do that first, and then we'll proceed with sentencing. So, Mr. Jefferson, you did plead guilty to a sexually oriented offense, which means you will be required to register as a sex offender. And I am going to explain to you at this time what those obligations and duties will be. There is a form here that I'm required to read to you, which sets forth all these obligations. You're going to get a copy of this. I'm not expecting you to memorize what I'm telling you, but I am required to read it to you, so I'm going to do that now. I'm going to ask that you pay careful attention. If you have any questions about it, make sure you ask. After I have read the form to you, I'm going to ask that you sign it. Your signature is simply acknowledging that I did read it and you understand it. Doesn't necessarily mean you agree with it, but it acknowledges I read it and you understand what your responsibilities will be. So let's begin. Let me just get some information here first before we get started. Your full name is Robert Alexander Jefferson?
Yes, Your Honor.
Social Security number is 272. Expected residence address is 5168 Austin Lane in Richmond Heights.
Yes, Your Honor.
I got a phone number of 216-926-2253. Is that accurate?
Yes, Your Honor.
All right, you have pled guilty to a sexually oriented offense, and you are hereby classified as a Tier 2 sex offender. You will be required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled there for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education, if that's applicable. You need to do that immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here in Ohio, you'll be required to register in person with the sheriff or any other appropriate official in that other state immediately upon coming into that state. You're also required to register in person with the sheriff of the county in which you establish a place of employment if you've been employed for more than 3 days or for an aggregate or overall total of 14 days in any calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you'll be required to register in person with the sheriff or other appropriate official in that other state if you've been employed for more than 3 days or for an aggregate or overall total of 14 days in a calendar year. Employment does include volunteer services. Now, you'll be required to provide to the sheriff any temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the day of initial registration, you'll be required to periodically verify your residence address, place of employment, and or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change your residence address, any place of employment, or any place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment and or place of education. You need to do that at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. Now, you will be required to further, you are further advised that in accordance with federal law, you must report any international travel to your registering authority no less than 21 days before any travel. Your failure to do so may subject you to additional criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to you or used by you to the sheriff with whom you most recently registered. Now, you will be required to comply with all of the previously mentioned requirements for the following period of time. And since you're a Tier 2 offender, it will be for a period of 25 years with in-person verification occurring every 180 days. Since your expected residence address, as you mentioned, and I confirmed with you earlier, is in Cuyahoga County, you will be required to register in person no later than 3 days after any release from any incarceration, or if there is none, 3 days from today, with the County Sheriff's Office located at 1215 West 3rd Street in Cleveland, Ohio, 44113. Now, your failure to register, your failure to verify residence at the specified times, or your failure to provide notice of a change in residence address or other required information, as I just explained, will result in further or additional criminal prosecution. You understand that?
Yes, Your Honor.
All right. Do you have any questions regarding any of these responsibilities or duties that I just explained to you?
No, Your
You
Honor.
understand them?
Yes.
All right, I'm going to hand you this form right now. The bailiff will hand it to you. In line 11, it reads, I acknowledge that the above requirements have been explained to me and that I must abide by all the provisions of Ohio Revised Code, Chapter 2950. That's the portion of our statutory code which sets forth what I just read to you. So I'm going to hand that to you now and have you sign. Place your signature on line 11. So I got the document handed back to me from my bailiff, and it appears you signed the document. Did you in fact sign it, Mr. Jefferson?
Yes, Your Honor.
All right, then I'm going to place my signature on line 12, which reads, I certify that I specifically informed the offender of his duties as set forth above, and he indicated an understanding of those duties to me. Let's place my name, my signature there as well. So, Mr. Stratton, I'll give this back to you. If you can make multiple copies, 1, 2, 3, at least 4. Copies, and we'll give those to everybody at the conclusion of the hearing. So you'll get a copy of that, Mr. Jefferson, at the conclusion of the hearing. All right, with that matter having been addressed, Mr. Goldberg, is there any reason not to go forward with sentencing at this time?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
I would, Your Honor. So we provided the court with a report, and I provided a copy to counsel for the state of Ohio from Dr. Stephen Levine, who is a principal at a practice east side of Cuyahoga County that deals with sexual issues, sexual dysfunction, and sexual criminality. Dr. Levine provided this report to me several months ago. Because of the cost and the lack of Robert having insurance, he did not continue to treat with Dr. Levine, but rather initiated treatment with BetterHelp, which is a online psychotherapy firm. Those were weekly sessions. I provided you with an accounting of many of them, but those sessions went up through last week. It's something that Robert has benefited from, and he continues and has continued up to now to access. That being said, I'll move on to the sentencing factors. First thing I would like to address is my client's remorse. My client knows that he hurt pretty much everyone in this room, with the exception of the court and the attorneys, both on the side of the victim and on his family who's seated behind him. He hurt everybody. He revealed part of himself that he had kept hidden, he managed to have kept hidden, that he didn't but should have sought therapy for before this happened. And he knows that life as he knows it will never be the same. And that, I'm going to ask the court to impose a sentence that is sufficient but not greater than necessary to serve the principles and purposes of sentencing. And I'm going to suggest that that can be done outside of the prison system, but even if prison is imposed, he can go and do his time, and he can come back, and he knows that his relationship with his son who is a half sibling of the victim in this matter, will never be the same. Probably the relationship of his loved ones with that child will never be the same. I believe that child's name has been changed since this incident. So when you look at his, well, first of all, the sentencing factors, I know the state of Ohio is going to be addressing them, so I will address and I will concede that there are several more serious factors that apply here. And as a felony too, we understand there's a presumption of a prison sentence, and that it's up to the defense to rebut the presumption by showing the recidivism less likely factors outweigh the more likely, and the seriousness factors are outweighed by the less serious. And I have to acknowledge that, and so my client acknowledges this as well. Number one, the injury was exacerbated by the victim's mental condition or age. We also can see that there was serious psychological harm. There may have been economic harm too, but for sure psychological. And finally, on that side, Mr. Jefferson was in a parental position. He had the duty to protect this child. And while I don't think he intended harm to the child, and while I don't think he anticipated harm to the child, because after all, this was a secret thing he was doing, he should have known better, and this is where he should have, his humanity and his fatherly instinct should have kicked in, and he should have got his help then, not after. And he acknowledges that. On the other hand, recidivism factors do weigh in his favor, Your Honor. He's got nothing. He had an OVI years ago, does not have an alcohol, drug problem, was tested at least on 2 occasions and was negative, and that's never been an issue for him. So prior to this, as I said, never had a problem with the law, had gone to school, achieved a 3.4, 3.5 average at school. In high school, went on to attend some college. That wasn't for him. And then he worked constantly in various positions in restaurants and bars, and was able to contribute to the well-being of his family. So, you know, he's shown that he's able to provide. He's shown that he's able to function in the community. I think something that came out in his sessions with Dr. Levine, and I imagine in his sessions with BetterHelp, is that he was a victim himself. And this is very common. He was a victim of sexual abuse as a 10-year-old. He was exposed to pornography at an early age, developed a pornography addiction. Not excuses for his conduct, certainly not an excuse for failing to proactively act in the best interest of this young person who he was in loco parentis with. But there is a psychological factor that wasn't addressed. He was also diagnosed with ADHD and depression as a teenager, and never really got the treatment he needed, and he should have. I think that the ORS risk assessment tool in the PSI correctly finds him to be a low chance of recidivism. I think his score was 12 or 15 or something really, really low like that. So these recidivism or recidivism less likely factors, I think, should weigh fairly heavily on this, and should be taken into consideration by the court, and I know they will be. He has expressed to me, I believe he will express here today in the courtroom, actual, sincere remorse for what happened. He expressed it to Dr. Levine, as he indicates. By the way, Dr. Levine, for what it's worth, finds that he's not a risk of reoffending, or he's a low risk of reoffending. But he basically told Dr. Levine everything there was to tell. I think it's also worth noting that when this phone was searched, there was the videos that resulted in this indictment. There was nothing more, and there was no indication that those videos were ever shared or copied or anything happened with those to get them into, put them out in the marketplace, so to speak. I don't know if that makes it better, at least it doesn't make it worse on the victim in this case. So with that said, Your Honor, we would respectfully request that the court consider the factors, and in looking at the presumption that we have for felony of the second degree, under 2913 D1 and the following sections, we would ask the court to find that a community control sanction would adequately protect the public and punish the offender, because factors indicating recidivism is less likely to outweigh the recidivism more likely factors, and two, not demean the seriousness of the offense, because the serious factors because the less serious factors outweigh the more serious factors. We'd ask you to make those findings. Your Honor, we understand that a community control sanction would include local incarceration, would include mandatory treatment or mandatory programming. We're asking for that. We're asking for for Robert to be given a chance to show that this is an aberration in his conduct in his life, that he's lost everything at this point, and that all he could do is come up from here. And we'd ask the court to impose a sentence accordingly. Thank you.
Thank you. Mr. Jefferson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Only thing I would like to say is I would like to formally apologize to all parties involved. I should have gotten help a long time ago, and unfortunately it's resulted in why we're here today. There's no words that I can say to show my remorse accurately. There's nothing that can be said. All I can do is prove through action, and that's all I plan to do. I've hurt so many people with my actions, and I know that I have, and I feel horrible about it, and I know there's nothing I can say that's going to change anything. And like I said, I just have to do what I need to do to better myself, to be a better individual in general. That's all.
Thank you. Mr. Goldberg, anything else on behalf of the defendant?
No, Your Honor. Thank you.
For the state, Ms. Gold?
Thank you, Your Honor. The victim and her mother are both in the courtroom today and would like to speak. Would now be the appropriate time for them to do so?
Yes. Whoever would like to speak, you can stand where it is that you're seated. State your full name, spell the last name for the court reporter, and then take your time and say whatever you'd like me to know.
My name is Angela Criolla, and I'm the mother of the victim. Your Honor, I'd like to start by asking you that you please do not perceive the defendant as a first-time offender. There is evidence to show he did not get caught until the third video was recorded of my little girl in the privacy of her bathroom. This incident was not the first or the only time. The victim is someone who always used to thoroughly enjoy showers and baths and to do things like make a playlist, light candles, have her face washed and hair things ready for afterwards, and relax while letting go of all of life's troubles. Now her showers are the biggest trouble of her life. In fact, she hardly takes them anymore. Most days she washes her hair in the kitchen sink. And it breaks my heart as a mother every single time I have to see this happening. Along with rarely being able to shower, neither the victim nor I can sleep much anymore. Most nights we wake up with nightmares as a result of the defendant's actions. The victim has been in therapy regularly since this incident and will soon be starting EMDR therapy, which is specifically designed to help her heal from trauma by making the brain reprocess her memories to decrease the vividness and the power it has taken over her life. The defendant used to refer to the victim as his precious little girl. He used to play school with her and read books to her. He watched her grow from a 7-year-old girl into a teenager, and he was someone we thought we could trust. She looked up to him as the only father figure she had ever had. The victim and I will forever have trust issues now. because we never imagined someone who we trusted so much with our lives was capable of such a horrible crime. The defendant is not someone the victim nor I are comfortable with ever having to see again, or with him having the ability to be anywhere we are at any time, even if by accident. The first thing the victim did when she found out she was hired at her job 4 months after the incident was immediately ask for a copy of the protection order to give to her boss. Even now, she fears on a daily basis he may show up not even knowing she's there. She fears every single day that he may show up at her work or her school or her home. Even with the protection order, we know it ultimately cannot stop him. The defendant has stolen our ability to feel safe and secure, doing everyday essential activities such as sleeping and showering. What he did also affected our mental health and left deep emotional scars that will last a lifetime. We ask that these things are considered when determining a sentence. Thank you, Your Honor.
Thank you, ma'am.
My name is Giovanna, P-R-I-O-L-A. Your Honor, the defendant has permanently changed my life in every aspect possible. I have been robbed from my normal teenage years and left with trauma I cannot manage to get rid of no matter how I try. On May 23rd, 2025, I was experiencing my first day of summer break. I was doing my nails and getting ready for a long weekend camping with all my family for the holiday weekend. I went downstairs to let Robert Jefferson know that I was going to shower and that I would be ready to watch my brother. He begged me to shower first. In his words, replying to me, telling him I was going to shower, saying, wait, can I shower first? I sighed kiddingly, and he expressed again, please, I'll be quick. I told him okay, thinking he just wanted to be able to do his hair and get ready for work while I was still in the shower. I proceeded to get in the shower and came out excited to use the face wash I had just bought. While I was washing my face, I saw flashing my brother's bath toy bed on top of the toilet. Looking in to find what I found was an old cell phone. It had been recording me the whole time. I tried to convince myself that maybe it was my brother's play phone, but after seeing a few old notifications and the wallpaper, I realized that it was not. At this moment, I didn't even get to feel violated because I was more concerned about my safety. Trying to figure out how to make it look like I had never found it. My mom wasn't going to get off work for another hour or two. I had no idea how the defendant would act if he knew how to he knew I had found the phone. When I couldn't figure out how to permanently delete it, I took it back to my room and put the phone under my pillow in hopes that if he were to come in, he wouldn't find it. I've never been more terrified in my life than I was behind that door, Your Honor. I sat there pushing the door shut, praying he didn't try to open it while I was messaging my mother. He knocked on my door asking if we could talk. I told him yes in a minute, and fear telling him no would make him mad. I truly did not know who was in the house with me anymore or who my brother was standing on the other side of that door with that day. Every second behind that door that day felt like an eternity and replays in my head constantly. When my mom finally made it home and ran up to my room, I begged her not to go back downstairs because I was scared of her getting hurt. Finally, after the cops were called, I was able to process just how violated I felt. I was just thankful in the moment that I caught it the first time on account of him telling my mom and the police this. However, that turned out to be a lie, which hurt me even more. I had to live in a house with someone who invaded my privacy for multiple weeks. Well, I caught the video before any more could be taken. If it weren't for the flashing on that phone, I wouldn't have. He could still be recording me or doing worse today. I have known the defendant since I was 7 years old. Over half of my life, he has been my father figure. He was the one who was supposed to protect me from all the bad in the world, but instead he was the bad in my life. This wasn't a one-time thing, nor did he... This wasn't a one-time thing, nor did the negative impact it has on me stop after that day. While he was no longer under the same roof as me, his actions have come with me everywhere. I have constant vivid nightmares that scare me awake and make it terrifying to fall back asleep. I can no longer shower in peace or in a routine that I enjoy, rather whatever one prevents me from spiraling that day. He has affected my physical hygiene and my mental health in ways that words cannot do justice. His actions occupy my mind every day to the point where I have to remind myself that he cannot do anything anymore. I no longer have any idea who Robert Jefferson is, and it disgusts me to begin to even imagine that the man I knew would do something like that. I was promised by the defendant when my mom was pregnant with their child that I would never have to watch him unless I wanted to. Yet I spent all summer watching him and continue to have to watch him a lot now. The defendant has left me with a life full of exhaustion on so many levels, and I just want peace and rest from this, Your Honor. Robert used to make this comment about being an afterthought in the household. Due to him working nights and meaning our family would go places to eat or go places without him. Parts of me used to feel bad, but unfortunately my entire existence was an afterthought for him. He didn't care about his actions, how they would affect his son or the girl he's called his daughter since practically the beginning. Notice how I didn't say he didn't think about his actions, but rather he didn't care. The defendant showed me in many ways that he did think about it and did it anyway. He had to dig out an old phone, which was packed away in my mom's room, which he was not sleeping in, find a charger, find a place to put the phone in the bathroom that was mainly used by my mother and I since he had one downstairs. Take the time out of watching my brother to set up the camera and proceeded to hide all these things from my mother and I. He even went as far as to look up on YouTube search how to fix a Samsung with the flashing screen. This wasn't a spur-of-the-moment decision, Your Honor, or one-time thing that he felt guilty for. It was a plan. It was carefully thought out. It happened multiple times before I found it, and would have happened multiple times after. Robert Jefferson didn't make a mistake. He made a decision, more than once or twice. Therefore, I feel his decisions should have serious consequences so that maybe I can begin to find some peace in my life. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. The state is asking for a prison sentence in this case. As Your Honor is aware, count 2 carries with it a presumption for prison, and it is the state's position that that presumption has not been overcome. A lesser sentence would demean the seriousness of the offense. Less serious factors do not outweigh more serious factors in this case. As outlined by both the victim and her mother, the victim suffered serious psychological harm as a result of the defendant's actions. She has been to therapy since this event. She has had continued nightmares and suffered from a lack of sleep, even over 6 months after this event has taken place. The defendant took from the victim the ability to feel safe and comfortable showering safely in her own home. Because of the victim's age, the defendant's actions exacerbated the effect on the victim. She was only 16 when she was a victim of the defendant's offenses, and the defendant's relationship with the victim facilitated the offense. It was because the defendant was in a loco parentis role, that he was in the victim's home, that he had the ability to share the bathroom with her, and he abused his role as a father figure to the victim. Now, these videos were taken on 3 different days, and each of these 3 days, the defendant had to take his phone, go to the bathroom when no one else was there, set up his phone so that it would be recording in a way that it would be most likely not visible to anyone else in the bathroom, and then after the victim was done showering or going to the bathroom, return to the bathroom so that he could take his phone and he could hide it so that no one would know what he had done. And this was something that he successfully carried out twice, and then on the 3rd day the victim luckily did see that phone and know that it was recording her. The purpose of this is so that the defendant could watch these videos back and satisfy his own curiosity. The state believes that prison is the only appropriate sentence in this case.
Thank you. This court has reviewed the pre-sentence report and investigation, victim impact statements. We received the report from the defense counsel. I've read that. Consider the facts and circumstances of the underlying offense that we're here for, the nature of that offense. Consider what's been said here in court today by the defendant, his lawyer, prosecutor, victim, her mother. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. For the factors in 2912, factors indicating the conduct is more or less serious. Court finds in the factors indicating the conduct is more serious that the defendant's relationship with the victim facilitated the offense. that relationship also was one in which the defendant was in a position of trust. He was the father figure to the victim, and he used that position of trust, abused that position of trust to commit this offense. That the victim here suffered serious psychological harm, still experiencing serious psychological harm, and that harm was exacerbated due to her age, being a minor. There's no factors indicating conduct is less serious. As for recidivism factors, the court finds the defendant has one prior OVI conviction. That's it. Factors indicating recidivism is less likely. The court notes that the defendant doesn't have any prior, aside from the OVI, any prior criminal convictions. This is it. He led a law-abiding life for a significant number of years, basically his entire life. And he has demonstrated, at least through probation and through his involvement with the court, a genuine remorse. There is a presumption for prison on count. Make sure I get the right count here.
Count 3.
Count 3, thank you. On count 3. And going through these factors as I just did, well, perhaps the court can make a finding that the factors indicating recidivism is less likely outweigh the factors indicating recidivism is more likely. There's no way the court can make the finding that the factors indicating the offense is more serious or outweighed by the factors indicating it is less serious. Prison is consistent with the purposes and principles of sentencing. The defendant's not amenable to any available community control sanction. You know, talking about the offenses and even the seriousness of the offenses, what struck me, something the victim said, quite frankly, is that these weren't spur of the moment. Spur of the moment would have been maybe one time. Would have been with your phone. But these were premeditated, they were planned. You had to go dig up that other phone, get that working, have it set up on multiple occasions. These weren't mistakes, as she said, but they were deliberate decisions. And a prison term, while there's no history here, is warranted. Therefore, it will be the sentence of this court that on count 3, defendant serve an indefinite prison term of a minimum of 2 years, maximum of 3 years. On count 4 and 5, he served a term of 11 months. Those will be concurrent. He's got credit for 7 days. I need to advise you upon your release from prison, you will be placed on post-release control for 5 years. While in post-release control, if you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term involved. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. I will order the forfeiture of whatever instrumentalities, contraband were set forth in the specification. I'm going to order the defendant to pay restitution to Angela Priola in the amount of $201. Defendant's ordered to pay all costs. Balance of the indictment is dismissed. Further need to advise you that you have been sentenced to a non-life felony indefinite prison term. There's a rebuttable presumption that you would be released when you've finished serving the minimum sentence. However, that is not guaranteed. The Department of Rehabilitation and Correction can rebut that presumption if at a hearing that you're entitled to attend as well, They demonstrate that you are not sufficiently rehabilitated, that you remain a threat to the community, that you violated the institution's rules. If any of that should be established at a hearing, you would not be released. You'd be kept in prison. They would select a new day for you to be released. That would be a presumption you'd be released in that new day, unless again in another hearing they establish the same factors. Under no circumstances, however, can you be kept in beyond the maximum sentence, even if you misbehaved the whole time you were there. I believe that covers everything. Ms. Gold, is there anything else I've omitted or need to address?
Your Honor, in addition to the Samsung phone being forfeited pursuant to the forfeiture specification at the change of plea, the defendant acknowledged that he would willingly forfeit a second Android phone, and I would ask that that also be forfeited.
Well, we did discuss that, so that the voluntary forfeiture, that will be ordered as well. Mr. Goldberg, anything else?
No, Your Honor, thank you.